welcome back. In this lesson, we're going to be discussing what happens when a physician and patient relationship turns sour and the physician needs to terminate the patient's contract. As we go through this, please note that this is provided by the Texas Medical Legal Team. It is available online through their SlideShare resources, and it's primarily geared towards physicians or nurse practitioners that are working within the field. What we're going to do is utilize this slideshow, but discuss things from the medical assisting point of view. One key point to remember is what we're talking about. The physician-patient relationship is a result of a contract. This can be expressed or implied between a physician and a patient on a voluntary basis and arises when a patient requests and is supplied medical information or treatment. This is listed by Fulbright and Jaworski in the Texas Medical Jurisprudence, 15th edition, 2004. As we see here, medicine is a business that comes with an ethical duty to patients, but physicians are within their rights to end a relationship that is no longer therapeutic. However, the requirements for ending that relationship are complicated for physicians in order to avoid allegations or potential claims in court of patient abandonment. Reasons why a patient would terminate the contract or a physician would terminate the contract happen for different reasons. Typically, on the physician's side, patient noncompliance usually happens when they stop showing up for appointments, they stop taking their medications as prescribed, or they're not following their treatment or follow-up plans. Failing to keep appointments also leads the physician's practice in a bind because those are slots that could have been seen by other patients needing medical care and potential income that was lost. You also are not ever expected to put up with rude, abusive, or aggressive behavior by a patient to anyone in the staff or the physician themselves. Anytime a patient does not adhere to the practice policies or they commit confidentiality violations or other grievous errors, we want to make sure that a contract can be terminated legally and appropriately. Failure to pay any balances leaves everybody in a financial bind. If a patient commits prescription fraud, that puts the physician's license and DEA charges up in court. And if a patient has filed a complaint with the state medical board, situations that are risky for physicians are when patients are pregnant and they're already in their second and third trimesters. It's difficult to terminate a patient contract if the physician is actively on call and covering a holiday period or a weekend period. Physicians treating hospitalized patients cannot terminate care until another physician assumes care first and they've been consulted thoroughly, or when a surgeon is treating a patient post-operatively, meaning if you had a general surgeon remove your gallbladder, that general surgeon cannot terminate that patient because they're not doing something appropriate. As soon as that patient's been operated on, anything directly related to that procedure or that physician can still be held liable, and the surgeon cannot terminate the contract with the patient. Physician practices that exist in rural areas where access to care is limited do not always have the option of terminating contracts because there aren't other medical providers that could assume care and take over treatment plans. It's also not professionally ethical to terminate contracts for pediatric patients. Any patient that is young, vulnerable, or impressionable should not be left without care. And patients with mental issues are also in the vulnerable patient status as well. Typically, OBGYNs and pregnant patients have difficulties discharging patients or when transfer cannot be arranged, and the physician is likely going to need to continue treating the patient until the patient care can be resumed by a non-obstetrical specialist and the presiding pediatrician for the baby once it's born. Anytime you terminate a contract, you want to make sure that any of the other on call duties are completely adhered to so that we don't leave anything uncovered or without care. Commonly asked questions: when can an on call specialist dismiss a patient? Generally, on call specialists in the emergency department must see the patient through the acute episode, including the follow up, until they're stable. But they're not obligated to treat the patient for unrelated conditions. So let me give you guys an example. If your grandmother goes into the ER for a suspected heart attack or possible stroke, the attending ER physician must continue to treat your grandmother until the vital signs are no longer in a life-threatening status, an adequate medical transfer of care has taken place with a provider who has agreed to see the patient for said conditions, and the patient is eligible to be discharged from the hospital and follow up with their routine physician. If Granny is complaining that she wants her ingrown toenail also addressed by that same ER physician, the ER physician is not obligated to deal with fingernails and toenails or skin tag removals. Their primary objective is to treat the potential heart attack or stroke. On-call physicians and hospital requirements are typically pretty complex, so we're going to go ahead and bypass the slides related to on-call physicians or hospital-based care until we reach the chapter and section for this course that directly deals with medical specialties. Rural areas, as we talked about in one of the beginning slides, are areas that are not major cities and have fewer than, I think, 5 to 10,000 people in their borders. If you have fewer physicians to care for patients in a rural area, it's going to be tough to be able to terminate the patient-physician contract appropriately without having adequate care available. Pediatric patients are also, like we said in the beginning, not ones that are easily terminated as far as contracts go, because it's difficult for a pediatric patient to comply with everything. You're really having to deal with patient education matters and speaking thoroughly and effectively to the care providers and the pediatric patient's parents. If the parent is the one that's non-compliant or is threatening the patient's safety, you must report this action. Child Protective Services, or CPS, has a duty to act, and we, as medical assistants in the healthcare profession, have a duty to report. Anyone with a psychiatric condition or an emotionally, mentally, or maturity-based developmental need needs to be taken care of even more specifically and even more cautiously. It's going to be difficult to terminate a contract when one's got mental health issues without having proper backup and other areas of approach or counseling or resources in place well beyond what the termination date would be. There's going to need to be what we call a continuum of care so that there is no lapse in coverage, because the last thing a psychiatric patient would need would be to have a prescription for a chemical balancing substance that would prevent them from having a psychiatric or psychotic episode, end up going without their medications and not having the ability to refill them. That would then fall on the medical responsibility and liability of the original prescribing physician at that point. Lawsuits and medical board complaints. Usually, if a patient has filed a lawsuit, then the physician is not able to continue their care because a relationship between litigants in legal matters, whether they're criminal or civil, cannot take place. There's actually court rules and regulations that state the plaintiff and the defendant should not be in communication because it does put the case in jeopardy. We've got a little bit of information for the provider of this SlideShare series, I highly recommend as medical professionals in the allied health field that you become familiar with different resources that are available either by mail in hard text bound books or with the digital age online. Most of these resources are available for free, and you are allowed to share them so long as you give credit where credit is due. So I like to leave the slides that introduce the company and where they got their information from in my presentations and make sure that I duly note these references, these materials who are already pre-prepared and are provided by said entity. So here's that slide for us. This is telling you a little bit about the Texas Medical Liability Trust and how to find them. Thank you for listening, and I look forward to seeing you further your career path within our CHCP MA program.